Say 43-year-old Chad Olson served in the Navy, loved riding dirt bikes, and was crazy about his young daughter. Friends say 71-year-old Curtis Reeves served in the Navy, loves motorcycles, and is a stand-up guy. Somehow, texting in this movie theater left Olson dead, Reeves facing life in prison, and a community and nation dumbfounded. Reeves is charged with second-degree murder, something his friends find unimaginable for this former SWAT team leader.
When they identified the person involved in this incident and as Curtis Reeves, I couldn't believe it.
All right, folks, there's the background on this bizarre case down in Florida, and joining us right now to talk about this, who better, by the way, this is a suburb of Tampa where it happened, who better than our friend Mark O'Mara, CNN legal analyst, defense attorney, of course, represented George Zimmerman. Hello, Mark.
Hey, Steve, how you doing? Good afternoon.
Good afternoon. Great to talk to you. Okay,
yeah.
So first of all, this is a crazy, bizarre case. That a police officer, former SWAT team leader and all that would do this, and now CNN is reporting that it's not the first time. Apparently a woman in the past had gotten up to use the restroom in the same theater, and Reeves followed her and made very clear that he didn't like her texting either. So what do you see happening here?
Well, there's so much to talk about. I'm going to start with my normal caveat, which is we really have to wait until we see all of the evidence. But having said that, the evidence that we've seen to date, it's just almost unimaginable. You know, when you're looking at a situation where sort of the new wave of road rage is now text rage, when you're sitting there, you have to look at the case and say, how did it possibly happen? Somebody said that, you know, the defense attorney is going to look at this case and try an insanity plea. Well, that doesn't cut it in Florida. Less than 1% of insanity cases ever go anywhere, and this is not an insane act. But having said that, you look at a 71-year-old guy who seems to have, I don't know, sort of gone off in a couple of different ways in weird kind of reactions. Maybe there is some mental health issue, but we are killing way too many people with way too many guns for way too little reason, and it's got to stop.
All right. Now, of course, you know, and to me, it's very interesting. By the way, I was very thrilled to be on with Carol Costello on CNN a couple of weeks ago, talking about the stories of the year, and I got to mention that the fallacy of the media coverage of the George Zimmerman case. One of the main fallacies was that he was told, "Don't get out of the car." I was so happy to be able to say that. You don't know, because you and I have talked about that forever.
Oh, yeah.
But you know, people also look at you and that case and say, "Oh, stand your ground." Of course, stand your ground was never invoked in that case. It's another myth.
Correct.
But people are now saying, well, could this be a stand your ground case? And what I see here is a guy in the case of the accused murderer who, you know, was an aggressor. See any scenario that stand your ground under Florida law could be used here?
Well, look, first of all, let's remember that this person, who was a former police officer, I think should be held to a higher standard because he's very well loud. You can stand up strong. You could even maybe take a chokehold. You can use a taser. You can use a baton. Weigh all of that before you get anywhere near using deadly force or a firearm. He should know better, having reacted. But having said all that, we have to look at what really is the essence of self-defense. And here's what it is. And it's been around for hundreds of years. If he reasonably believed that he was in imminent fear of great bodily injury or death to him, then and only then he's allowed to react with deadly force. There is no scenario that has been identified yet, popcorn thrown or not, which would suggest that he had the right to act with deadly force because, one, he could have withdrawn himself. Two, there's no evidence that there was any imminent fear of great bodily injury. And even if you were to say Florida is a stand-your-ground state, so that if you're confronted with deadly force, you don't need to retreat. You still have to have the initial deadly force before a stand-your-ground suggestion or scenario would kick in. None of that, according to any of the factors that we've seen so far, gets anywhere close to self-defense. And, of course, that's what the judge who looked at the probable cause affidavit said. There is strong evidence of second degree and gave the bond that she gave.
Yeah, no, that seems to make sense. I just didn't. It really would make a mockery of that line of defense, which I do believe is legitimate in many cases,
Sure.
if that were to be invoked in this
Exactly.
case. All right, well, very interesting, very educational on the insanity situation and the stand your ground situation, and we will follow this. And I hope all's well, and we'll speak to you soon, sir.
Sounds great, Steve. Take care.
Take care. That's Mark O'Mara, ladies and gentlemen, CNN legal analyst and defense attorney, of course. George Zimmerman's attorney in the Trayvon Martin case. We're privileged to have him on this show from time to time. In the next hour, my friends, we will be joined by someone who has represented many of the groups targeted by the IRS, and we'll discuss the fact that it looks like there'll be no criminal charges filed in the IRS scandal, not by the FBI, and of course the Justice Department investigator is an Obama contributor. We'll also talk a little bit about climate and the trouble the climate warming people or global warming people are finding themselves in right now. All that straight ahead, if you keep it here, on the Steve Malzberg Show on Newsmax TV and radio.